Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com.
Hi, everyone. Thank you for joining us for this episode of the Immigration Lawyers Podcast. We have a great guest today, Michelle Mendez. And Michelle is the director of the Defunding Vulnerable Populations Program of CLINIC, which is Catholic Legal Immigrations Network Incorporated. CLINIC has a lot of different shops or places. I've worked in the one in Southern California, a lot, great people over here. They're experiencing this weird situation with the Attorney General. There was a decision that came out, and the name of it was regarding matter of Bay Area Legal Services, Inc. It was a double decision kind of thing. I'm not an expert on what's going on with that kind of stuff, so I thought I'd go right to the source and talk with Michelle about it. Thank you, Michelle. Thank you for coming on the show.
Yeah, thanks so much for having me and for being interested in this issue.
For sure. So how did this all start?
Yeah, sure. So, first of all, I think those attorneys who have seen the two decisions stemming out of the same case are probably not super interested in the decision because it deals with what's called the RNA program, the Recognition and Accreditation Program, which is where, or the office within the Executive Office of Immigration Review that oversees the accredited reps, right? Accredited reps who work in nonprofits that are accredited to provide legal representation to the immigrant community. And so I think a lot of attorneys are just not as tuned into the RNA program. And I'll just continue to use RNA program for short, knowing that it deals with accredited reps and who they are. So I know that a lot of people are probably not familiar with this decision, or maybe if they saw the two decisions that came out of this case, they were probably like, I don't really know what this entails. I'm an attorney, accredited reps, whatever. But it's actually a pretty important decision. As far as how CLINIC came into the decision as it is because we have a nonprofit network of approximately 380 nonprofits across the country that are part of our network, and a good chunk of those nonprofits rely on accredited reps to provide legal services to the immigrant communities. So just like a little bit of background now that I've mentioned that, it's unlikely that people know about this decision or care about this decision, and that our network really is comprised of a lot of accredited reps. Just a little bit about the accreditation program. It's been around since around the 1970s or so. It's a program that was designed specifically to expand capacity. And I'm sorry, as in COVID times, you will hear background noise, you will hear my dog.
Yeah.
But to expand capacity for representation for indigent immigrants. And it's a great program. So it's through this program that non-attorneys, those of us who decided to have a lot of school debt, went to law school, and then there's some of us who decided to become accredited reps and just go to work at a nonprofit. And so they are authorized to practice in front of USCIS, or they're also authorized to practice before the immigration courts and the Board of Immigration Appeals. So there's two levels. There's the partial accreditation, which is just USCIS, and there's full accreditation, which is for the courts and the Board of Immigration Appeals.
Okay. And so what was the first decision that came out of this case?
Sure. And so keeping in mind that there's this RNA program that's been around for a while, that its intent is really good, is to expand capacity for representation for immigrants, that it's something that's closely watched and run by EOIR, that CLINIC is in charge of a network of nonprofits who are part of this RNA program, and that we provide excellent training to them. We then see this amicus invitation from the Director McHenry, and it has these 4 questions that are related to the program. And so knowing our interest in the RNA program, knowing how important accredited reps are to representation for immigrants, knowing how well they do it, especially those that we, I can say we train. But they've got a lot of natural skill. We immediately said, okay, we've got to submit a brief on these 4 issues. And then lo and behold, after the decision came out, we saw that we were the only organization to actually have submitted a brief. So it actually appeared as amicus. And so, and that's how we came into it, just because of our background, because of our network, because of knowing that accredited reps are really important. And so we got the decision. We saw that we were the only ones to have filed an amicus brief. And there were 4 issues. We responded to all 4 issues. They dealt with basically, go ahead.
Oh, yeah, what were the 4 issues?
Yeah, so the 4 issues were about the issue of what happens when an accredited rep submits an application and it's denied. Mm-hmm. So generally when it's denied and they seek reconsideration of the decision, they only have 30 days to submit that request for reconsideration. So the first question was about basically, is that deadline subject to equitable tolling? The second issue was about the legal standard for evaluating a request for reconsideration of a prior denial. And the third issue was about the standard of review for the administrative record. So should it be de novo, for example, and that's what we advocated for. The fourth issue was about the prior precedent decisions of the Board of Immigration Appeals in recognition and accreditation cases, binding on consideration of requests for reconsideration now. And that fourth issue is a little bit tricky because let me just say that there have been a lot of dubious changes with the RNA program under this administration that I won't get into because there's just a lot, to be honest.
Sure.
And then, yeah, but basically this program, as I mentioned, is within the realm of EOIR. Yeah. It went from being under the oversight of the Board of Immigration Appeals. So any decisions issued about the RNA program used to come from the Board of Immigration Appeals, for example. But then ultimately, the RNA program now is housed under the newish Office of Policy under EOIR. And we, Clinic, have submitted some FOIA requests about this office. It's very secretive. We think that a lot of where the attacks on immigrants have come out of that office in particular. So anyway, the regulations changed as well. So there have been a few changes over this administration. And so that's what that fourth issue really goes to. So we actually, they ended up agreeing with us on 3 out of the 4 issues. The only one that they went against us on was the first issue, which is that the 30-day deadline for seeking reconsideration of a denied accreditation renewal or new accreditation application, that's a mandatory deadline that is not subject to equitable tolling. And we spent most of our brief specifically on this issue saying, like, it's got to be subject to equitable tolling, specifically, like, think about all the things outside of the control of the accredited rep and the nonprofit. For example, COVID-19, right? And by the time you get that decision in the mail, because of course it comes in the mail, by the time you get that in the mail and then you send it off, you're working with few days to really.
It is unfair.
Right.
It's not just in this context. There's 30 on USCIS also. It's a big problem because you see the stamp date on the envelope, and when you actually get it, it automatically eats up. And in USCIS, sometimes they'll give you extra 3 days for some of these, but it's even longer than that. Or the date they have stamped that they wrote the letter is not the date that the envelope is stamped. So they already held on to it for a couple of days sometimes. So there's always problems with that issue. Exactly.
And the immigrant practitioners that listen to your podcast, normally they're very familiar with this phenomenon, I think, right? Yeah, and then there was a fifth issue that a fifth holding had within the decision that talks about the skills that are required to seek a renewal or a new designation of accreditation. And so if you're seeking full accreditation, so in order to practice before EOIR, for the immigration course, before the Board of Immigration Board of Immigration Appeals, that you have to have skills that are essential for effective litigation. And so, of course, I just mentioned our involvement in the RNA program, why we care about it, how we train and support the accredited reps, why they're important to the immigration field. So I've already explained all of that, and that's what really led us to submit this amicus brief. But now, after getting the decision and seeing that we were the only organization to have done so, it wasn't that surprising, I guess, since we're so involved in the RNA program. But we take a look at the decision, and there was a lack of clarity, and the accredited rep here in this case was denied, right? He was denied his accreditation for becoming a full rep, and then the reconsideration request was ultimately denied because he didn't submit it within the 30 days, and that's what the first issue was about equitable tolling, right? But then we look at the decision, and it really faults him for not doing things that are really only able to be done by somebody with full accreditation. So taking testimony, submitting briefing to the court, things that only somebody with full accreditation has the authority to do, right? And the decision wasn't clear that if he was going from partial representative status to full accredited status, or if he had previously been a full accredited rep in the past and then became partial and then became full. But it seemed to suggest that and fault him that he hadn't done these things in immigration court, but it's like, how could he have done them? He was a partial rep. He never had the opportunity to do them because he wasn't authorized to do them. And had he done them, that would be unauthorized practice of law. So in this decision, the director McHenry faulted the accredited rep because he didn't have the skills essential for effective litigation. So the accredited rep was seeking full accreditation, and it wasn't clear if when he was seeking the full accreditation at the time, he was a partial rep or he was not a rep at all, because when you seek to become an accredited rep, you can seek to become fully accredited off the bat, or just partially accredited, or go from partial to full accreditation. So there's various ways that you can do it, right? So it wasn't clear where he was at the point, or if he had previously been a fully accredited rep and then became partial. None of that was clear. So faulted him for not having those skills essential for effective litigation. But if somebody is seeking full accredited rep status, that's when they would be able to do those things like take testimony, submit briefs to immigration court. It's only when you're fully accredited that you can do those things, right, with the authority of the DOJ. Mm-hmm. And so it didn't make sense to us that he would be faulted for not having skills that he couldn't have acquired had he not engaged in unauthorized practice of law, right? And we obviously never want to make that suggestion or inference or intimation. Like, we never want to leave that door slightly open. We want to be as clear as possible, like what is authorized and what is not. Mm-hmm. And so the decision, in lacking clarity, we thought that there was a real risk in the public thinking that you had to engage in unauthorized practice of law to get the skills that were essential for litigation. So we reached out to Director McHenry. We reached out to him via email. We sent him a letter, which is posted on our website. And we saw clarity. We said, here are the places in the decision that are not clear, and we would like for you to consider amending the decision to provide the clarity that's needed, given the risk of suggesting that someone has to engage in unauthorized practice of law. Mm-hmm. And then the next thing we knew, they issued the second decision. And the second decision,
well, I mean, before issuing that, they seem amenable to doing this. So you talk with them and communicate with them. It seemed like they're listening and understanding.
Well, so John, it's funny because, as I was mentioning before, there are a lot of issues in the RNA program right now that we're concerned about. And so we had actually had a conversation about another issue as well. And they're very closed off though to talking to us about this issue, about amending the decision, because we were not a party to the case. We were simply amicus curiae, and so kind of was, but also there was another issue in that conversation, and so alas, what we got is this second decision that basically told us, no, you don't have the authority to come and request an amended decision. This is not your place. And so the interesting thing is that in telling us that we don't have authority to seek further action on this matter because of our position as amicus curiae, he still took the time in the decision to provide the clarification that we sought from him in the first place. Now, the other thing that's interesting is that in the past, EOIR, the board, they've been amenable to amending decisions, to updating decisions. They've been amenable to that, and so it's interesting that they chose to go this route as opposed to a more collaborative spirit, given that our concerns are concerns that should worry everybody, but especially EOIR, which is unauthorized practice of law, in a decision that was ultimately not clear. Now, of course, the director disputed that it was not clear and disputed that we had authority to seek the clarity. But like I said, the decision nonetheless, in telling us we had no authority, gave us the clarity that we needed. They went that route instead of just simply providing a quick amendment. And we suggested how to do that, even just a footnote, without having to really touch the rest of the decision, just a footnote.
It's bizarre. I mean, the administration wants to play hardball in every single aspect, even when it's not necessary. It's a fight on everything, and we see it on every aspect from USS, UIR to CBP to DOS. Everywhere you can, it's like be difficult. I mean, right now with the funding issue, there's reports that the executive isn't even issuing a funding request from Congress to make up for USCI's shortfall. So it's dragging their feet, and a lot of it's not necessary. It makes their own. What I'm seeing is the people that are working there getting frustrated, because a lot of this is creating work for them that's not necessary. It's really easy to just talk this over. A lot of these things don't need to happen, but it's unfortunate when you have a program like this. I mean, you know what the intent is and the leadership. So, and now Director McHenry, this is one of the first decisions he's made since he became director. Is that right?
Yeah, so just a couple of things. So as you mentioned, the resources, the furloughs, just obviously this isn't USCIS, we're dealing with EOIR, but like how many resources went into issuing a published second decision as opposed to simply tweaking a footnote in the first decision, right? Like you got to wonder from that perspective, like why, how does this make sense? And you put it into the big picture as you just did, and then you're especially like, why does this make sense? But then, yeah, this is on the RNA program. This is the first decision since the changes that I mentioned before, where the RNA program was under the Board of Immigration Appeals and then went to the Office of Policy with Director McHenry being on, the one that would be issuing these decisions per the regs. This is that first decision for the RNA program.
Does it look like they're trying to weaken the program so they would get less representation in this group?
In my professional and personal opinion, yes. And this is not just based on this situation with Matter of Bay Area Legal Services. It's based on just my big picture perspective of the RNA program and everything else we are seeing in general. I think so. And, I'll just add here, John, that I think there's a misunderstanding too among attorneys as to what being a accredited rep means. I have found that a lot of attorneys, accredited reps are basically notarios, right? And we all know that word in Spanish mostly, but an authorized practitioner of law, because they don't really know the difference, or I'm not really sure where that misunderstanding comes from. But accredited reps, they're people who are specifically themselves personally accredited by the Department of Justice, right, to be in this position. And they also have to work for accredited nonprofits. So there's a 2-level kind of accreditation that has to happen for somebody to have that accreditation. They have to work at the right place, and they themselves have the right accreditation. So they are not anything near notarios, but unfortunately there's just, like I said, this misconception. And what they really do more often than not is help immigrants. And so that I just wanted to put that out there to make sure that there's clarity from among us, because we need to stand together. We need to support this program. We can't, there aren't enough attorneys to represent everyone, and there are few, I don't know the percentage, but not every immigrant can afford private attorney prices. So there's got to be some options there. So given all the benefits of the program, given the long-standing nature of the program, I do think that those are the reasons why this administration is seeking to diminish, undermine the program.
It's fallen in line with what their stated goals are. Now, let's talk about your background a little bit. So how did you get involved in immigration?
Man, I so much prefer to talk about cases than myself, but, because you are lovely and you've asked me to come on and talk about Bay Area legal services. I will talk about myself. So I am an immigrant myself, and I became involved in immigration work. Before I was an attorney, I mean, you could say in college, I tutored refugees from Africa, English tutoring. And then thereafter college, I worked at Care Coalition as a legal assistant. I actually worked at ALA. I was the advocacy coordinator. And then I went to law school specifically for immigration, and the rest is history. I graduated law school in 2008, and I've been involved in immigration since.
And so tell us more about Clinic and what their operations involve.
So this is a subject I do like to talk about. So Clinic is an organization that historically the bread and butter has been expanding the ability of nonprofits to provide competent, ethical legal services, and also to provide the training and legal support that those accredited reps, again, or attorneys in those nonprofits provide. That has been, for the most part, like what Clinic is known for. There's also a awesome religious immigration services program, and they represent foreign religious workers who want to come to the United States to work, right, in their whichever church, religious community, etc. And then our program, the Defending Vulnerable Populations program, we started really as a project within another program, but we started after the election, after the 2016 election. And we've now grown so large because there's so much need. Again, like there's just so much work to go around for everyone. And we have our team that is located all over the country. We work remotely. So my team with Defending Vulnerable Populations is located, for example, in Pennsylvania, in Colorado, in New York, in Minnesota. And we have 3 buckets of work. Our first bucket of work is to provide support to the immigrant defenders when it comes to matters such as removal defense. We do some FOIA support as well. We do asylum support, and then special immigrant juvenile status support. So we provide training, practice advisories. We also do training on trial skills, and we partner closely with the National Institute for Trial Advocacy. So that's like the first big bucket of work. The second bucket is litigation. For example, we've got a few cases already, some really good ones. And also we do appeals on matters of importance to like PFRs to the Court of Appeals. Our team is and I was gonna say my colleagues are the representatives for Mr. LEA. So we all know the LEA family-based social group, particular social group. We are counsel on that case now. And then we do pro bono cases as well to keep our skills up, since we do the trial skills training as part of our first bucket of work. And then we have our BIA pro bono project, which just, I encourage everybody to check that out. Amazing project, but we just do a lot under that bucket. And then the third bucket are special projects, remote special projects that respond to crisis situations. Oftentimes, we have a remote motions to reopen project. We've had this for a while. So we do motions to reopen on a nationwide basis. And then once the case gets reopened, we try to use our network to then get somebody on the ground locally to represent that case once it's reopened. We have a remote bond project model that we created, and now we've used it twice. The second most recent time that we've created that model and used that model was for the Mississippi raids that happened, unfortunately, last year. We partnered with Lawyers for Good Government.
What happened with that? We don't hear about that at all. I mean, they let a lot of people, I remember some sort of families and kids, they kind of let him out, but that's the last thing I heard last year. Is there any updated news on that?
So everybody that we could have represented to get out of detention on bond, they've been represented now. Some of those went on to become appeals, but unfortunately, as we all know, when people are detained, they give up. They give up more easily. But we did have somebody get released because of COVID-19 mostly. We were able to get that individual released, and that has led to a lawsuit actually in New York with a New York ACLU. So the data that we received as part of that remote bond project, that was really crucial for then a lawsuit to come out of that work. And so, yeah, we were very successful in the cases that we were able to represent, but a lot of people gave up, and a lot of people had given up or had been deported before we were able to get on the ground. And I just want to say that it was really thanks to Lawyers for Good Government, because they're the ones who recruited all the attorneys from the different law firms. Mm-hmm. And my colleague, Tanika, overseeing that project and did so marvelously. And it was just a really—
Her name again and cut out. I want to make sure she gets recognition. What was her name?
Yeah, Tanika Vigil.
Okay.
Colorado.
I've worked with clinic here in Los Angeles. You have listeners that are, a lot of the clinic chapters across the country, listeners of the podcast always reach out to me. In LA, I've worked with them. But a lot of people who do practice, like with USCIS, they'll get your legal briefs that are on the clinic website. When something pops up, when you have good SEO, your search results for your website come up when different training kind of stuff, dealing with EOIR or even USCIS kind of stuff. It's a lot of good information on clinic. If people wanted to donate, I mean, the donate button's there, but what kind of help could they do to support your mission? There's donation, which is on the website. I'll have a link to it on the show notes, but any other way they can support your mission?
Yeah, I mean, aside from just, the regular donations route, we're always looking, like I said, for counsel for a couple of projects, but the Motions to Reopen project. So again, when we get a case reopened, we are looking then for local counsel to take over that case. Mm-hmm. And those cases are literally all over the country. We also have our Separated Families project. So we oversee a database, we oversee work, and we keep information on the formerly separated families and where they've gone in the United States to try to see like who's got a hearing coming up and who doesn't have counsel. And then we try really hard to place that case with counsel so that these families who have already been through so much cruelty and suffering and trauma unnecessarily, that they have hopefully a defender with them through the process in front of the immigration judge. So, the traditional, if you want to take one of these cases that we're not ones to provide direct legal services, that's our nonprofit network, right? They're the ones in the trenches providing the direct services, and we're just here to support, challenge issues in federal court when we see that there are certain trends, for example. But we do have a couple of projects where we need individuals to represent cases directly, and that when we recruit outside of our network. So that's probably the most important piece.
Do you contact like the local clinic chapter? Is that the best way to do it, or how would they get involved?
Yeah. So it's funny because while we have this network, I know it seems like it would be similar to kind of like AILA and the AILA chapters, but all the nonprofits in our network are really distinct entities, and they only come to us for like the training and the legal support. They'll come to us for like ask the expert when they submit a question to us for technical assistance on their case, right? Or they'll come to a webinar, in-person trainings when we were having them, but they're really super like separate and apart entities. And we just happen to work with them fairly loosely within our network. So I would recommend that if anybody's interested in taking on potentially like a formerly separated family case, or a motion to reopen, or just kind of wants to be on standby, to email, they can just email me and I will get it to the right person on our team.
Okay.
So that's probably the easiest way.
So I'll get your email because I want to make sure it's the right email that I have. I'll get after the show. But thank you so much for coming. We learned a lot from this, and I hope to have you on again to keep us posted on these changes that are happening.
Great. Thank you so much, John. I appreciate you having me on.
So stay on the line, but I'll say goodbye, everybody. Thanks, everyone. Have a good one.